Merlin, can you hear me?
Good morning, Judge. Yes, I can.
Okay, Merlin, tell me when we can start. I see most
It's
people have logged on. There's some having difficulties.
correct. Betty's currently busy with them, Judge. We're on 61 delegates at this stage.
So there's seven missing.
Correct, Judge.
Okay. It's 11. It's a long call. I have to cover a
I think,
lot. So
Judge,
yeah.
we're at 10:59. In a minute's time, I think you can start.
Okay.
Okay.
All right.
Okay, Judge.
Thank you.
Pleasure, Judge.
Hello. Merlin, I'm going to start. I see just about
Ye
everyone's logged
yes,
on now.
Judge. I think you
Yes.
can start. You may,
Okay,
Judge.
everyone, good morning and welcome to this course on litigation strategy. Um, it's quite an intensive course and it requires concentration on your part. Presenting virtually is not easy because I can't see you and I'm unable to tell if you're following me or not. But I'll do it at a pace that you can um, uh, follow me and understand what I'm saying. The most important thing about this webinar is for you to actually understand the concepts. Now, to assist you, you have a set of notes or a manual that was written by me. What you see on the slide presentation is in your notes. Why I'm saying this is because I want you to listen to me and understand rather than write notes. Writing notes is of no use because you never read them afterwards anyway, and you've got the notes. So you can read the notes afterwards to enhance your understanding, and it's a reference point for you at a later stage. Now, I'm going to start this morning dealing with what is not in your notes. It's related to litigation, but in a slightly different way. I'm going to go through various principles which are not directly related to process and procedure in the High Court, but it is related to how you conduct litigation in your offices. Now, there's been a number of changes that have taken place within the profession that you must be aware of. Now, we all know that litigation, a litigation practice, is something that's essential for any law firm. Your clients, whether they're commercial or non-litigious clients, will eventually get involved in disputes and they'll require you to resolve them for them. So there are law firms who litigate full time. That's their job. That's what they do. Or you have a law firm that has a mixture of all the disciplines. But when it comes to legal practice, it's the litigators that take center stage. I mean, no one cares if you're a conveyancer or you do wills and estates. But the people in the forefront of the profession are the litigators, people who prepare their clients' cases, go to court, and they want to win the case. So the first thing I want to express is something that you must take away from this webinar, and that is being a good litigator means you apply your mind every step of the way. You think through everything that you do, every notice that you send out, every pleading that you write, every affidavit has to be thought through. You apply your mind. I know that a lot of litigation starts by client coming in, gives you a story, you have a rudimentary idea of what the matter is about, then you find a precedent. You copy and paste from there, and you issue the summons. Your opponent does the same thing, except that the plea is a bare denial. Now, can you imagine what a disaster this is? Because the plaintiff hasn't pleaded correctly. The defendant does not have a viable defense on the papers. And now you're going to enter into case management, and you're going to talk to a judge, and you're going to end up at trial. It's a complete disaster. You want to be successful. You want your clients to resolve their disputes quickly and cheaply. And that's where the world is heading with litigation. These copy and paste experts are out. Okay, they become irrelevant. Now, I'm going to take you through various stages of litigation, and we're going to talk about the best practical way of dealing with it. I'm not going to give you a lecture on the uniform rules, and I'm not going to deal with the case law. I'm going to tell you what you do as a lawyer. Now, one of the problems that we had in our courts is that, and we still have the problem, cases take too long, 3 to 6 years, ridiculous, and it costs too much money. So we introduced this thing called case management, which you're all familiar with. And I'm not going to deal with case management in detail here, but I have to deal with certain aspects of it. But the first thing you must remember about case management, in our courts are not very well developed when it comes to case management. We've lagged behind the other countries like England, Canada, Australia, Europe, and the United States. We've lagged behind. To give you an idea of how far we lag behind, in England, cases in the High Court are concluded within 6 to 9 months. That's how quickly they finish cases. The Canadians finish their cases from issuing of papers to finality through judgment or settlement, 3 months. Can you imagine that? 3 months. Now, that's what the client wants. So we've introduced case management. What is case management? It's not about managing the case. It's about managing the lawyers. The cause of the delays and the high costs are the lawyers. Now, one of the luxuries that we had in this country, and continue to enjoy it in many cases, is that we get paid even though we lose the case. So you go to court, your client loses with a cost order, and then you present client with the attorney and client bill, and they pay it. Well, I've got news for you. There's been enormous changes in the profession internationally. And one of the things that has impacted litigation and has impacted your practices is contingency litigation. So now you don't get paid if you lose, you only get paid if you win or you succeed in settling the matter. So that has had an impact on litigation departments in law firms throughout the country. It has an enormous impact. One of the main impact areas is that now the risk of costs is borne by you, the practitioner, the law firm. It's not borne by the litigants. So the litigant comes to you and says, the client comes to you and says, I have a case, I'm suing, you get paid a success fee. You get paid if we win or if we settle on good terms. Now, this has the effect that the risks in the case now become your problem. So this business of copying and pasting and running the matter and getting paid irrespective of the outcome, that's going to change, and it's changing forever. It means that as a lawyer, you have to become seriously efficient, and you must know exactly how to deal with a dispute. And that's what I'm going to tell you. Now, there are certain principles that apply, basic principles that as a lawyer, you are not to forget. Every case that you do, apply these principles. The first principle, there's a quote there from a law lord, Lord Brown Wilkinson. He was asked in an interview, what does he think is the first principle of litigation and judging, resolving cases? This is his answer. He said, the first principle of judging is dirty dogs don't win. And I promise you that is a very important quotation. Just remember, dirty dogs don't win. So what does that mean? What does it mean, dirty dogs don't win? It means that you can no longer use the courts for purposes other than resolving a genuine dispute between the parties. All forms of abuse of process will not be allowed. Now, there's a new trend that has taken place across the countries around the world, that courtrooms and the facilities around a court are scarce resources. They are paid for by the taxpayer. Lawyers and their clients cannot abuse those facilities. They cannot go to court simply because they can. You go to court because there is a rational purpose, and that purpose is to solve the dispute. So who are the dirty dogs? The dirty dogs are the ones who come to court with what we as lawyers refer to as a non-meritorious case. In other words, it's a case where your merits are poor. You come to court with a bare denial as a defense. You come to court with a cause of action which is not likely to have happened. It's improbable. You are wasting scarce resources. We say you can't do that anymore. But there's a trend worldwide that we are no longer merely going to punish the litigants. If the lawyers come to court and present nonsense, the lawyers are going to pay the costs. De bonis proprius cost orders are coming out thick and fast now. We had this old excuse, you come to court and you present a version that is nonsense, and the judge looks at you and says, but how am I to believe this? Do you really expect me to believe this? And the lawyer says, well, my lord, those were my instructions. And we got away with it. Oh, so those were your instructions. Okay. But you're an officer of the court. Surely you must know that your client's case is nonsensical, or that your client has no defense. You can't plead anything that is viable legally. So why come to court? You just know you're going to lose. Now, here's the thing. Under contingency litigation, you cannot do that. Why? Because the risk of the costs is on you. Never mind a de bonis proprius cost order, you've got no chance of succeeding, which means you've got no chance of getting paid. So what you have to do now is deal with litigation the correct way. And I'm going to show you the correct way. And the correct way to start with is for you to stop being a dirty dog, okay? There are two classes of dirty dogs, by the way. The one class is the client who comes to you and says, I want to go to court. You say, but this is not the merits are poor. Client says, no, I'm instructing you to go to court. That client's a dirty dog. They're going to lose. And by the way, if you get a client who insists on going to court and it's a bad case, just take a very huge deposit, okay? Because when it comes to paying, that's when the client is going to drop you, okay? Be careful. The second class of dirty dog is the lawyer who knows this case has got no merit, but insists on going to court, and then tells the judge, those were my instructions. Well, trust me, you'll never get away with it anymore. The second principle is the most important part of litigation is for you to master the facts of the case. The law is not important. Trust me, the law is the easy part. The difficult part is for you to master the facts of your case. You must know what happened according to your client's version of the facts. In other words, what actually happened according to your client's version. Now remember, if it's a genuine dispute, your opponent will also have a version. And remember, the same principle applies to your opponent. Your opponent must come to court with a viable, legally viable defense. Otherwise, your opponent's a dirty dog and shouldn't be there defending the case. So, before you do anything, when it comes to litigation, first thing, get the facts. Now, I'm saying to you, don't even write a letter of demand if you don't know all the facts. We had a tendency in the past, and look, I'm a culprit as well. I practiced as an attorney and as counsel. We never got to grips with the case until a week before the trial. We started looking for witnesses, interviewing witnesses, and so on, a week before the trial. And most of you know, I mean, even today, go to court. In this division of ours here in Johannesburg, the same, and in Pretoria and in Durban and Cape Town, go and see what happens to most cases on day one of the trial. The last thing that happens, the judge walks in and says, yes, Mr. Smith, plaintiff's attorney, and he says, I'm going to make my opening statement and my first witness is available. I promise you, if that happens, most judges will faint. What actually happens is that the matter gets postponed. Well, we all know it. We all know these things get postponed all the time. So why does it get postponed? It's not the client's fault. It's because the attorneys are not ready. Or they found out the week before the trial, when they met the first witness, then they realized that the pleadings are not compatible with the version of the witnesses. So what do you need to do now? You need to amend, which means you have to postpone. More time lost, more costs. So before you do anything, get the facts. Second principle. The third principle, and this third principle is related to the dirty dog principle. never go to court. And I mean, don't do it. Don't go to court with a version of facts that is improbable, or it is implausible in relation to the facts and circumstances of the case. Now, how do you work that out? I'm going to show you. Clients sit down and tell you a story. Most lawyers, most of us, we can immediately tell if this is nonsense or not. Is this a genuine case? Or is this nonsensical? Someone's taking a chance? We can tell. But it's very, very difficult for lawyers to say to a client, hey, look here, you're a liar. You're a dirty dog. You can't say that. I mean, it's your client. You have to be gentle. You have to charge a fee. So what do? Well, there's a solution to that. When you get an improbable version, tell your client. Say to the client, look here, I don't think a judge will accept that version. Let me tell you why. Now explain to client with reference to the facts why the judge will find this case to be improbable. That's very important. Now, if you go to court with a version that is improbable, you are going to lose. I mean, just take it, you're going to lose. All right? Let's assume for purposes of this webinar that all judges are competent. They know what to do. We know it's not entirely true, but you have to accept that the judge is a well-trained, experienced lawyer. They will see right through a nonsensical story or an improbable version very quickly. So why you would want to even go to court with such a story, I have no idea. So those three principles you must understand. Another change of mindset is you have to now, this is the new method of litigating, is for you to stop being adversarial. Okay? South African lawyers, we're no different to the other lawyers in those countries that use the adversarial system, all the Commonwealth countries, the United States. We have become adversarial animals. All we can think of is donoring the other side. We want to beat them. We want to take points. We want to get cost orders against them. We want to be rude and nasty and show them a point. Just stop it. It doesn't work anymore. Adversarial litigation does not work. What you want to do is cooperate with your opponent. Talk to the other side. And I will show you that the rules are now compelling you to do so. In fact, what the rules are saying, Rule 41A, is that if you can resolve a dispute without starting litigation, you will have a very satisfied client. You see, clients don't want their cases to be hanging around for 3 years. They want the matter resolved as soon as possible and as cheaply as possible. So if you can resolve the matter without even issuing a summons, that's what you do as a good lawyer. Now, I know I get asked this question all the time. So how do we make money then? If we're not running the case for 6 years, how do we make money? Well, it's been conclusively proven that if you run a case for 6 years, you don't make money. Of course, you charge a fee for a notice, you charge a fee for an affidavit, you get charged for a postponement, and so it goes on. Fact is, your overheads exceed what you're actually making on that file. What you want to do is close the file as soon as possible and bank the money. Okay? But it's also been proven that satisfied clients will recommend your firm and keep coming back to you. That's where the money is. Okay? So running matters for 3 to 5 years or 6 years doesn't make money. Now, this is an aspect that I want to deal with before we go any further. This whole question of onus. You've all learned in civil procedure that the civil standard of proof in order to discharge the onus is on a balance of probabilities. Now, I can tell you, I studied civil procedure and evidence at university. I don't recall anyone at university, any lecturer, being able to explain what is actually meant by balance of probabilities. They don't explain it, mostly because they've not run trials. Now, let's step back a little. When you go to court, why do you win? Why did you succeed? Because you persuaded the judge to accept your version of what happened. That's why you win. When lawyers say, my witness was fantastic, and we won the case, what the lawyer is saying, my witness persuaded the judge to accept his or her version. Now, if the witness comes up with a story or a version that is improbable, the judge doesn't believe it. What do you think happens? The judge disbelieves the witness, and you lose. Now, let's focus on the judge for a moment. Our courts, the judges, are adversarial judges. In other words, they're not sitting in an inquisitorial court, they're sitting in an adversarial court. What that means is the judge cannot enter into the arena. The judge does not inquire into the truth. In fact, it's nothing about the truth. The judge sits there and has to make a finding of fact based on what the parties present. So the judge can't go beyond that. So if you present a witness whose version is rubbish, you're not going to succeed. Oh, you can have a very eloquent legal argument, but the judge will say, but hold on, I don't accept your version. My finding of fact will not favor you. I disbelieved your witnesses. So what happens when a judge in our courts listens to a witness? The witness has been sworn in. It's Mr. Mokoena. He's testifying. Do you think a judge knows that Mr. Mokoena is telling the truth or perhaps is lying? Do you think judges know that just by listening to by listening to the evidence? Of course not. Judges don't know what happened. They were not on the scene. They were not there when the contract was entered into. They have to hear what happened from the mouths of witnesses. Now, a judge, well, judges are not gods. They can't look at a witness and know that this witness is telling the truth. They have to listen to the story. And there are various mechanisms judges use for determining whether to believe the witness or not. But there's one mechanism that is the most important mechanism. The judge listens. The judge is not asking, is this true? The judge is going to ask a different question. The judge is going to say, is this probable? Now, that is something judges can do. That is something all lawyers can do. Lawyers can listen or interrogate the facts, and they can then decide whether that that version is likely to have happened. In other words, is it probable? If it is not probable, you reject the version. You don't have to say it is not the truth, therefore I reject it. All a judge has to say is, it is not likely to have happened, I find it to be improbable, therefore you have not discharged the onus on a balance of probabilities. You see what it means now? It simply means that if you're a dirty dog, you're going to lose. Your version must be probable. So how do you know the version is probable? There's a good test. As lawyers, you must remember this. Listen to the whole story. Now, every dispute, and I mean each and every dispute you will deal with, will have every dispute is going to have a set of undisputed facts. Now, every dispute is made up of two sets of facts. There are those facts that the parties don't dispute. They are common cause. They're undisputed. Then there's the component of the disputed facts, which requires a trial to resolve the dispute. Now, the version around the disputed facts must be supported by the undisputed facts. Then you can say it is likely to have happened. But if the disputed version is contradicted by the undisputed facts, it means that it is improbable. You get that? Just think about that. That's the way it works. Well, let me give you a simple example. We all know about motor collisions. Let's say the plaintiff is driving in the city, and there was a collision in a robot control intersection with the defendant's car. The defendant's version is that he was driving at 60 kilometers an hour. And the plaintiff's version is that the defendant was speeding and couldn't stop in time when the robot changed color. Now, the undisputed facts are that the robot was working, the weather was fine, the police arrived, and they made a police report. A police officer made a note that the defendant's car left a skid mark of 25 meters. The policeman photographed the skid mark, measured it, and noted it. It's not in dispute that the defendant left a skid mark of 25 meters on a tarred road in fine weather, dry road, undisputed. Now tell me, what are the probabilities that the defendant was doing 60? You see, his version is I was doing 60. But the undisputed fact is that he left a skid mark of 25 meters. Now, it's not likely that he would have left a skid mark of that length if he was doing 60. If he was doing 60, he would have stopped. Okay? So do you understand how it works? So immediately a judge can say, well, hold on, wait a minute. Of course, it's possible that you could have been doing 60. That's possible. But that's not the test. The test is, what is probable? Because anything is possible, but a judge tests it on the probabilities. The judge says that version is not probable because you could not have left a skid mark of 25 meters. So do you see what is meant by a balance of probabilities? In plain language, if your client's version is improbable, don't go to court. Simple as that, whether you're plaintiff or defendant, applicant or respondent. Because in discharging the onus, if you're the plaintiff, the onus is on you to prove the material facts which make up your cause of action. If those facts amount to a version that is improbable, You will not be able to discharge the onus. You lose. Okay. That is something you must never forget as a lawyer. Okay. So what we're going to do, we're going to deal with this in a 4-part strategy. In your practices, there are 4 stages at which you will perform your functions. The first and obvious one is for you to obtain instructions. That's obvious. But what's not so obvious is, what does it mean to take instructions? It means you have to get all the relevant available facts before you do anything. Now, sometimes you get a case where your client is facing a time bar, prescription, or a time bar in an insurance contract, and you've got a day. They left it late. You still have to do your best to get as much of the facts as possible, because if you didn't get all the facts and you got the cause of action wrong, you did not interrupt prescription. You're in serious trouble, okay? Your client's going to lose. So obtain all the facts. And by that, I mean everything. Names of witnesses, witness statements, a review of all the documentation, chronologies, everything. You must have it before you start drafting. Secondly, when you have the facts, you must formulate a cause of action or a defense and plead it correctly and persuasively. Now, what is meant by correctly? Correctly means you must plead the peculiar facts of your case. Now, what happens in our courts is that practitioners plead using precedents. And that's the biggest mistake you can make, okay? Don't plead using precedents, because the precedent is not based on your client's version. It's based on some general set of facts which don't apply to your client. So you want to be accurate. Your pleadings must be an accurate representation of your client's version of what happened. Persuasively simply means the version is probable. If the version is improbable, or there are improbabilities within the facts that make up your version, you cannot persuade a judge, because you won't discharge the onus. Proof on a balance of probabilities. Thirdly, you will then deal, well, let's go back to the second one. Pleading a cause of action is impossible to do if you don't know the facts of the case. It's absolutely impossible. The third phase is for you to get through the pre-trial procedures, things like discovery, experts, conferences, judicial case management, all of those things you will have to deal with. And I will take you through those things. And the last thing is the trial itself, which we will deal with. Each of these 4 steps is equally important. Do not treat any one of them lightly, okay? This third one with the pre-trial procedures, many firms, many of the practitioners go through this as if it's a process that they have to do. Like they'll file a notice to discover, they'll file a discovery affidavit without applying their minds to the schedules. They'll file expert notices without really interrogating why you need an expert for what dispute of fact. You just go through the processes. That's a bad idea. Okay. Then we have this thing, practice directives. Some of you may have realized by now that our uniform rules are very outdated. In fact, the whole lot has to be thrown out and we have to start again. The world has moved away from our uniform rules. A lot of it works still and it's still applicable, but really it needs to be streamlined and much of it is irrelevant. So what happened is judges started managing those rules and procedures with practice directives. What is a practice directive? This is a directive that comes from the judge, president, or the deputy, and it's applicable only in that court. So the first problem with case management, with practice directives, is that it's not uniform. The uniform rules, they're called uniform because they apply to all the courts. Directives don't, they apply only to that court. You will make a serious mistake if you start litigation without reading the directives in the court where you are issuing your papers. These things are updated all the time. In fact, in some divisions like Gauteng, you can lose track of the number of changes that keep coming. And attorneys complain bitterly that the directives have become terribly onerous. And I agree with them, they have become terribly onerous. And the problem will only get resolved once we have a proper set of uniform rules. So, like it or not, you have to comply with the directives. Now, I mentioned case management. Case management is mostly done through directives. You won't find it in the uniform rules. So, for example, you can't call, you will not be allowed to call an expert if the experts had not met and filed a joint minute. You see, that comes out of case management, and it's in the directives. You have to comply with it. Then some of the courts, not all of our high courts, have a trial certification procedure. So you can't get to trial until the case manager or the registrar certifies that you're ready for trial. Now, trial readiness means that when you get to court, you are not going to ask for a stand down. You're not going to ask for a postponement. When you get to court, you're going to tell the judge, I call my first witness. That's it. Off you go. You will have to attend case conferences. These are driven by practice directives as well. And there are directives around discovery. Discovery is now quite strictly managed, as it should be, because attorneys were abusing it. You discover only what is relevant to the issues, and the discovery must be proportionate. Okay, it's relevance and proportionality now. Otherwise, you'll be disallowed the costs. Containment of issues. Now, you plead correctly, but after pleadings close, you are supposed to attend a case conference with your opponent, and you have to decide what is the tribal issue. You have to write that down. A judge will want to see it. Okay. And of course, if you don't comply with the directives, you end up with all these costly postponements. So what we want to do is introduce a non-adversarial approach. I told you it is better for you and your client to cooperate with your opponent. And that cooperation is what underpins the case management. Judges have introduced case management, and much of it is based around getting the attorneys and advocates to sit down and talk to each other. The idea is to go to court and utilize scarce resources only when it is necessary. and only where there are other non-adversarial options. Now, this has now been included in the uniform rules, and we'll come to that in a moment. We are now encouraging our courts, our practitioners, to avoid needless adversarialism. You know this nonsense about writing to the other side and saying, our client's rights are reserved in toto, or you will be ipso facto barred. We will seek an appropriate cost order. We will meet you in the appropriate forum. You must have seen all this nonsense being written between law firms. Well, just stop it. If you can't settle with the other side, then at least settle as many of the issues as possible. So you go to trial with maybe a single issue or two issues. The trial is shorter, less costly, and your client will be a happier client. We now compel you, in terms of the rules, to apply your mind to alternate dispute resolution. In other words, negotiation, settlement, mediation, arbitration, those things are now in the uniform rules. I will come to it. So, very much, it is part of your strategy in your practices to include mediation and settlement, and as well as arbitration in your practice. What that also means is that you must be ready to engage in those things. You must have negotiation skills. You must know who to go to mediate what kind of case. According to the nature of the dispute, you need to find the right mediator. You must know how to call on the other side, have a meeting, and in a cordial way discuss the matter and possibly settle it. You must also have access to people who can hear disputes in an arbitration. Now, most of you know that the commercial work has fled our courts. We all know the reasons why. We don't have to go into it. But there are no commercial cases in our courts anymore. And it's a great pity because the common law is at a standstill. Now, it's because what we have in our courts is just RAF and medical negligence and that other favorite unlawful arrest. I mean, it's just, the judges are sick of it. All the commercial work has gone to arbitration. It's sad, but then you need to, the principles you're going to learn here are applicable to an arbitration. An adversarial arbitration, the same principles apply. Okay. You are expected to cooperate, resolve issues, and our courts are already beginning to punish the lawyers. Go and read Rule 37.9a. It's been there for a long time, but the judges never applied it because judges were too soft on the practitioners. Not anymore. I've seen time and time again attorneys and advocates being struck with punitive cost orders. De bonis propriis, okay? And there's a very good judgment. I think it's the first of its kind where principles of case management were applied and the lawyers were disallowed all their costs. And that's the case of Brownlee versus Brownlee. You can see it's a divorce case. And what happened in this case is what happens in a lot of divorces. The parties appear to be at loggerheads. They become the lockhorns. They are fighting over everything. The court file grows and grows. The office files on each side grows and grows. And the costs are out of stratospheric levels. This particular case, that's exactly what happened. By the time the parties came to court, they were broke. The judge in the matter, a very competent silk, looked at this file, worked out very quickly what had happened. It was not the parties that were fighting, the husband and wife. It was the attorneys who were fighting. They were picking fights with each other, opposed interlocutory applications, amendments flying around, allegations against each firm, and it was completely out of hand. The judge looked at this file and said, but hold on, all of this nonsense was caused by you guys, the attorneys. Disallowed all their costs and punished them. So just be careful. Deal with matters sensibly. Your opponent is a colleague. You're not on a battlefield, okay? Those days are gone where we battled each other and the whole purpose was to win, win, win. The purpose here is to resolve the dispute, okay? Now we come to Rule 41A. I'm going to go through this quite quickly. It is fairly new, and by now you know that there are notices that you have to send to one another, the law firms, in terms of 41A. The difference here is the difference, by the way, generally, uniform rules are there to facilitate the resolution of the dispute. If you look at every rule in the uniform rules, they serve a certain purpose. But you know what's happened? The attorneys merely complied. They did not actually comply. A good example is discovery. So they discover. What do they discover? The whole office file, okay? So you end up with bundles of 600 pages being discovered, most of which, in fact, 80% of which is irrelevant to the issues. You know, we did that sort of thing. What's happening now with our rules is judges are focusing on whether or not the parties and the attorneys actually complied and met the purpose of the rule. That's the important thing. You must meet the purpose of the rule. And we're applying that to Rule 41A. You can't deal with it merely as compliance of a procedure. You must apply your mind to it. You must provide evidence that you did so that the judge can see there was actual compliance, not mere compliance. The rule has a very wide definition of dispute, the subject matter of litigation between parties or an aspect thereof. So it's very wide, and it can encompass any dispute which is a subject of litigation. Here, there are certain disputes where judges will focus on and will insist on compliance. The best example is family law disputes. You know, the Brownlee case was family law. The divorce involved children. Family law cases, whether it's a divorce, custody, maintenance, access, those things, should never be fought in an open adversarial court. Parties who are married to each other and had children should not be tearing at each other in a courtroom. That happens, that adversarial nonsense happens because of the lawyers. Okay, and I'm not scared to say it because I can prove it. It does not belong there. And if you look at countries like Europe, the UK, Canada, United States, Australia, India, all the Commonwealth countries, they've moved divorces out of the courts, the adversarial courts. They say it doesn't belong there. The Canadians deal with divorces in mediation. They don't have a trial. They say it's not right and it's not on. And we are heading that way too. If I have time, I'll tell you how we're doing it. There are some courts where they use mediators in divorces that come to trial. The judge doesn't hear it, the judge just sends it to a mediator. The purpose is to settle the whole dispute. That's the main prize, through mediation. But we know that mediation doesn't always work. But if mediation can still result in a narrowing of the issues, which means that the number of court hours you will need is drastically reduced. Let's go to subsection 2. The rule applies to every new action or application proceedings. And here you are required to send a notice to the other side, calling on them to indicate in writing whether the party agrees or opposes referral to mediation. Now, there's a problem. We've always had ADR in the South African legal system, but it didn't work. And you know why it didn't work? It's because it relied on both parties agreeing to it. So if you wanted to go to arbitration, the other party had to agree. If the other party was being abusive, doesn't have a defense, they're not going to agree to it. They'll say, no, I'll see you in court. Let's run it for 6 years. That's what they're going to do. Now, we are compelling parties to use ADR. And that's what 41A2 is about. We recommend that when you take instructions to commence litigation, you must right there take instructions on the possibility of settlement. That is what the rule is intended for. Now, let me give you some practical advice. Earlier on, I told you, get the facts first. Then you decide if there's a cause of action. Then you decide if the version of your client is probable and that you will be able to discharge the onus. But very often it will happen. And it happens a lot with defendants' lawyers, where you will have a problem with the version. You will have a serious problem with the version. You don't believe it. You think it's improbable. Well, then you use 41A. That's when you say to your client, listen, this version is not going to be accepted by a judge. I don't think we'll discharge the onus. Why don't we talk to the other side? Maybe we can talk about a payment plan or something like that. Just settle the matter. And that works. It works well. On the other hand, if you decide to go for litigation, you file papers and so on, but your version is improbable, to start off with, you'll have problems with the pleadings, because now the pleadings will be read by a case manager very soon, within 3 months. As soon as pleadings close, someone's going to, a judicial case manager will read the pleadings. Firstly, they'll look for a cause of action in the plaintiff's particulars of claim. Then they're going to look for a defense in the plea. If they don't find those things, the lawyers are summoned and they are told, listen, these pleadings are rubbish. You have 3 weeks to go and amend them. Otherwise, go and talk settlement. That's what's happening. Subsection 3, this rule facilitates for the mediation process to be introduced or used at any stage of litigation. In other words, at any stage before judgments, the parties can agree to refer a matter, the whole matter or a single issue, to mediation. But the whole process is controlled. Now, what is this? This is what we call court-annexed mediation. You must have heard that phrase, court-annexed mediation. In other words, it's not mediation which the parties privately agree on. it is part of the court system, it's part of the dispute resolution system, and you are compelled to go to mediation. In fact, a judge can tell you, hold on, this issue here can easily be dealt with in mediation. I'm referring you in terms of Rule 41A, go to mediation. This is how they do it. Now, there's some suggestions that I have, practical suggestions. When you and your opponent agree to mediation, it is absolutely essential for you to know what the issue is. You cannot instruct a mediator and say, talk to these people, they're having a fight over something. See if you can talk to them and sort it out. So what is a mediator going to do? He doesn't know what the case is about. He hasn't read the pleadings. You have to first, between you and your opponent, agree on the issue. Then there must be a shared understanding of the scope of the mediation. You can't say to a mediator, here's the case, go and sort it out. Okay, it doesn't work. You can also seek guidance of a judge or a case manager where the matter has already commenced and you have to seek leave of the court for a referral to mediation. That will also be a good time to settle or define the issues with input from the judge or the case manager. That's very important. Where the parties agree to referral to mediation, the rule requires two things. The parties must present a joint signed minute of agreement to refer. Now you'll see, if you read through Rule 41A, it provides for the parties to record everything in writing. And there's a reason for that. There has to be a paper trail. Why? Because the judge needs to see there was actual compliance and not mere compliance. Prior to commencement of mediation, the parties must enter into an agreement to mediate. So they're bound by it. But, it's belts and braces. That's a little superfluous because there's a rule that says go to mediation. So you don't really need an agreement. But there's a purpose here. When you sign an agreement to mediate, what you have to put in that agreement is the issue that requires mediation. That's the trick. That's what we want the lawyers to do. We want the lawyers to apply their minds to the tribal issue, put that in the agreement, and that helps the mediator as well. The rule does not encourage rigid formality. The parties are expected to sign an agreement, just an agreement. You may include a definition of the issues and the scope of the mediation in the agreement. Sub 6, this is a very good provision. It's designed to encourage mediation. All communications, oral or written, and documentation used in mediation is treated as confidential. And in the event of continued litigation, cannot be admitted in evidence. So the parties must feel free to talk during mediation, just make full disclosure. If it doesn't work, there's a confidentiality requirement and you can't disclose those facts. And by the way, those of you who appear in court, either as an attorney or advocate, there is a rule of ethic that says that if you do disclose this kind of information, you would have breached your code of conduct and you will be disciplined. So be careful about that. And then costs. There's always a problem with costs. By the way, are you aware that when the new Magistrates Court Act and rules came out a couple of years ago, they already had court-annexed mediation in it? But it doesn't work. It's never worked. In fact, the Law Society went off and trained a whole lot of attorneys countrywide to become mediators, and they presented the Department of Justice with panels of mediators who will serve that purpose in the magistrates court, that's regional and district. It never happened. And the reason, of course, is the department did not have the funds to implement it. So it's all very well, we've got the act and the rules, but we've got no funds to implement it. Story of this country. Anyway, the fees must be borne equally by the parties, unless they agree otherwise. When the court considers an order of costs, when concluding the action or application, the parties may refer the court to the notices in sub-rule 2 and may also draw the judge's attention to offers and tenders. Now, here's the reason why everything had to be in writing. Because now you get to the end. You didn't settle, but the reason you couldn't settle was because someone was being unreasonable, but that couldn't be disclosed to the judge in the trial. But now you can disclose it. Say to the judge, look here, look what the other side has been doing. We want a punitive cost order. Okay, so be careful of that. You can decide, oh, I'm going to be tough in the mediation. I'm going to admit nothing. By the way, you get those lawyers who have this attitude, I admit nothing, prove everything. And they fold their arms and look very smug. Well, let me tell you, those lawyers are a bloody nuisance. We want to get rid of them, okay? Because they do not advance the interests of their clients, okay? It's what we used to call in the old Transvaal a harde gat attorney, okay? Now, this question of fees and costs, it's always a problem, okay? What they did in many jurisdictions around the world, and that is what we were trying to do here for the magistrates court, is they created a panel of mediators, suitably qualified, members of the profession, attorneys and advocates, and we put them on a tariff. So they couldn't charge what they liked. There was a tariff for fees that they could get paid, an hourly rate or whatever the tariff is. So it contained the costs. Most of you know that if you go to mediation, say at AFSA, the costs are enormous. I mean, I worked it out. It's around 150 to 200,000 Rand a day. So these things are not cheap. But 41A was not designed to create another procedure which is going to cost the litigants a lot of money. That would defeat the whole purpose. So when you refer matters to mediation, the fees the mediator is meant to charge must be reasonable. Where there's no tariff, then there has to be a reasonable fee. And don't be afraid to negotiate this with the mediator. If a mediator is being expensive or they're charging a fee your client can't live with, well, find another mediator, okay? At some later stage, I'm sure it's going to happen. We will have tariffs for these mediators. Those of you who are in Cape Town, they have a very good system working there with divorces. There's I think it's called FAMSA, that has an agreement with the court there for divorce matters. That if a matter comes to court and it's a proposed divorce, that they will mediate. They will act as mediators at a very reasonable tariff, and it works really well. I've seen it work, and it's excellent. Okay. Now, I'm going to move away from 41. I want to get on to the hard litigation. You have to focus on the judge. I spent some time earlier talking about the role of the judge. What is it that judges do? How do you discharge the onus? Now, it's very easy for you to get caught up in the litigation between you and your opponent, and you forgot the judge. Now you get to trial before the judge, and you're not really prepared. When you go to trial, you must be prepared to persuade that judge to find in your favor. Let me say again, it's not about the truth, okay? You can sit in your office, interview witnesses. You can be satisfied that they are telling the truth. These are the most upright people. We must win. Guess what happens? You go to court, and the judge says, oh, the plaintiff called Mr. Smith as a witness. I heard Mr. Smith testify. I was unimpressed. I was not happy with his demeanor. He was not a good witness. He contradicted himself. He hesitated before answering questions. He avoided questions. And I reject his version. Now what? Where did it go wrong? Okay. It went wrong in your preparation. You prepare witnesses on the basis that they will come there and present a version that firstly is probable, must be probable in relation to the facts. Now, there are other rules. There's that famous rule of evidence. All relevant evidence is admissible unless excluded by a rule. So everything your witness says must be relevant to an issue. Otherwise, the witness is irrelevant. And the evidence that the witness presents must be admissible in its form. For example, it must not be hearsay. It must be from personal knowledge. So that is what you have to do. Why do you do this? In order to discharge the onus on a balance of probabilities. Now, if your witness's version is improbable, the judge disbelieves it. That's it. That's the end of the case. Now, you are likely to encounter judges in two roles. Firstly, you'll encounter judges, well, if you bring interlocutory matters, you'll encounter judges in the motion court. That's different from trial work, unopposed motion court especially. So don't worry about that. But you will sit down with a judge who is a judicial case manager. Now, can you imagine if you wrote pleadings that came out of a precedent? The judge is going to say, but what is this? I don't know what happened. What's the version? We are now going to deal with these different roles that the judges play. So what does the judge want? The judge wants to be able to read the pleadings and be able to work out three things. Firstly, what is plaintiff's version of what actually happened? Number one. Number two, based on the peculiar facts of the plaintiff's version, what exactly is the plaintiff's cause of action? What is meant by cause of action? What are the facts that the law recognizes as giving the plaintiff a claim? That's what the judge is looking for. And thirdly, based on the defendant's version, what is the defense? Do they disclose a defense? And what is it? What the judge wants to do from pleadings is to get a clear idea of what the triable issue is. Now, we learned at university that the purpose of pleadings is to define the issues. I guarantee you, even now, post the case management era, pull out 10 files out of the High Court. Go and read the pleadings in all 10 of them. Ask yourself in respect of each file if you know what the case is about. Just try it. I sat on the bench for many years. The file comes, the first thing I'm going to read is the pleadings bundle. I'm going to read the particulars of claim, the plea, and I'm going to read the minutes of the pre-trial conference. That tells me what the case is about. It doesn't. It doesn't. Because the pleadings came out of precedents. No one knows what's happened. For example, now you've all read this nonsense in accident cases. The issue is negligent driving. Whose negligent driving caused the collision? That's the issue. That's the tribal issue, simply stated. How is this pleaded? The defendant was negligent in one or more of the following ways. He failed to keep a proper lookout. He failed to apply his brakes timeously or at all. He drove at a speed that was excessive in the circumstances. And of course, my favorite, he failed to avoid the collision when he could and should have done so. Now, for God's sake, if you read that, do you know how the accident happened? Of course not. You have no bloody clue. So the judge is left in the dark. What actually happened is that plaintiff says the defendant drove through a red robot. That's what happened. But you don't plead that. You say he failed to keep a proper lookout. So what the hell does that mean? So don't plead like that, okay? Like divorces, failure to communicate. For God's sake, what is that? No love and affection. Who knows? Can any one of you actually tell me what is meant by no love and affection? No. The cause of the breakdown was that she beats him up and he drinks a lot. Why can't you plead that? No. Okay? Failure to communicate. What nonsense. You see this nonsense all over the pleadings. It's just precedent rubbish. Don't do that. And the reason lawyers do that is because, firstly, they don't know the facts. Secondly, they have not worked out the cause of action based on their own version, their client's version. They have not worked out what the defense is based on their client's version. That's what a good lawyer does. Okay. Now you're beginning to see the picture of how you have to change your strategies in litigating in the modern era. Okay. Now, judges do not encourage parties to bring interlocutory applications. Now, what are interlocutories? An application to compel discovery. Why did that happen? Because one of the lawyers didn't do his work. So now the other lawyer has to file a notice of motion, supporting affidavit, serve it, file it, and all the rest of it. Then the other lawyer reads this application, and you know how brilliant this profession is. He caused the trouble, but now he reads the application, he charges for it. He marks a fee. Why? Because he didn't do his work in the first place. Then they go to court and they obtain an order. 10 days later, the affidavit is filed. I mean, what a waste of time and money. We don't want to do that anymore. When proper case management comes in, interlocutories will disappear. It's happened. I've seen it in England, where the interlocutory applications, the motion roll, the unopposed motion roll, which is full of it, go and have a look, it disappeared completely, okay? Judicial case management will be directed at resolving as many disputes as possible, including disputes of fact, okay? It's only where there's a dispute of fact that cannot be resolved, genuine dispute of fact, it goes to trial. And then we identify that fact and try that fact, not the whole story. Discovery you have to apply your mind to discovery at an early stage. Now, one of the things about discovery is that it was abused. I mean, you've seen it. You go to court and plaintiff's counsel or attorney stands up and says, "My lord," in a very pompous voice, "may I hand up the defendant's bundle or plaintiff's bundle?" 4 lever arch files get handed up. I've received 4 lever arch files from each party. So I'm sitting with 8 lever arch files. So we run a 3-day trial. Do you know what we did? We used 5 pages out of 8 lever arch files. Now, who pays for all this nonsense? The poor client has to pay for it. Okay? We don't do that anymore. That's what we call wide discovery. We banned it. Now we want narrow discovery. It means you only put in your bundle, you only discover what is relevant. Okay? And I'll deal with the electronic discovery at a later stage. With case management, the first time you sit down with the judge in a case conference with the judge, with your opponent, you are expected to articulate as the lawyer what your version of the facts are, whether you're plaintiff or defendant. Then you have to get ready to make admissions of fact. The judge will actively assist the parties to confine and define the issues. Now, this is very likely to happen where the parties filed vague, precedent-based pleadings. Now, one of the techniques in case management is to assist the parties to make admissions of fact so that we curtail the length of the trial or the amount of court time the matter will require. Now, can you imagine you're sitting there as a lawyer, a judge says to you, well, Mr. Jones, tell me, can you make the following admissions of fact? And if you're not going to make those admissions of fact, tell me why there's a basis in fact for not making those admissions. What are you going to do if you don't know all the facts? In fact, it would be downright irresponsible of you to make any admissions if you're not familiar with all the facts of the case. Because how on earth will you know that you're making an admission that's going to prejudice your client, or you are making an admission that will help your client's case? You won't know. So it's a dangerous business to start litigation without being an absolute master of the facts. And remember, judges first make a finding of fact before they apply the law to the facts. And judges now will punish litigants who do not cooperate. And this includes practitioners. Go and read Rule 37(9)(a). Now, I found this a quotation. This is, I have a book which was written by, it's an English book. It was written about how judges make decisions. This is what was said. A judge engages with real people and real conflict. Easily understood. Where invariably he is faced with a choice between opposing parties and has to do the best he can with the evidence available according to the burden and standard of proof. That's what the adversarial system requires. An inquisitorial system, like they have in Europe or most of the Middle East, the judge investigates the facts in order to determine the truth. The adversarial system doesn't work like that. What you see on the screen is the adversarial system. Now, rule number 1. When a judge is faced with opposing parties, what that means is the judge is faced with mutually destructive versions. In order to make a finding of fact, the judge has to accept the one version and reject the other. So how do you do that? By hearing the versions through the mouths of the witnesses. The first thing, if the version is improbable, the judge separates it out immediately. I don't believe it. You've not satisfied the burden of proof. Simple as that. Now you know why I say never go to court with a version that is implausible. You will lose. Your job is to assist the judge to find that your client discharged the burden of proof. Okay? Not your opponent's client, your client. Okay? And you can only do that if your witnesses are impressive. And the first rule is the version must be likely to have happened. Now, this is what a House of Lords judge said. A judge's reasoning and conclusion must be practical, suit the facts as found, and provide an effective, workable remedy to the winner. Now, you see, that's what a judge has to do. You know, the judges don't sit there and spin a coin. Sometimes looks like they did, but that's not what they do. In the adversarial system, judges come to a conclusion. The system requires the judge to give written reasons for the conclusion. Now you know why some judgments get reserved for so long. You must give a reasoned conclusion. You have to write down your reasons. You have to say why you made that finding of fact and why you applied this decision and not that one. But judges also want to be practical. They're dealing with people. They want to resolve the dispute. They want to help the parties. As a lawyer, it is your job to tell the judge, look, here's a workable remedy. Now you know why judges like draft orders, because the judge wants to see how you think the matter can be resolved. That is why we have heads of argument. No judge is expected to come to a conclusion without first informing herself of the facts and the law. Okay. The facts are the most important. Why? Because the judge knows the law, but the judge doesn't know the facts. You present the facts. And the first rule about the facts is that you come to court with a good version, a probable version. Otherwise, you're the dirty dog. So before you start, do the following. What are the material facts of your client's case? Okay. Now, initially, it's quite difficult to separate out what's relevant, what are the issues and what's relevant to the issues and what's not relevant to the issues. It's not so easy to do. The only way you'll get it right is if you first obtain all of the facts. Now ask yourself, assuming you can prove those facts, in other words, you have a version that can provide proof of those facts, what remedy can your client practically obtain? Practically meaning, can you come up with a remedy that will provide your client with actual relief? In other words, there's no point in getting an order that is of academic value. Like most lawyers know that if they sue for an amount of money, the first question goes through your mind is, if we win, would the defendant be able to pay it? If the defendant's a man of straw, there's no point. You go through a whole process, spend a lot of money, and get nothing out of it. By the way, if you are dealing with the matter on a contingency, that's the first question you'll ask. Okay. If we win, can the other side pay? If the answer is no, then you can't take it on a contingency, obviously. You'll have to tell client, listen, you'll have to fund this litigation yourself because there's a risk. And I'm not taking that risk, okay? For any litigating lawyer, there is only one rule. obtain the available facts first. It's facts first. You are to make facts great again. I sound like a mad politician now, but you have to make the facts great again. Not your precedent, the facts. So why does it go wrong? It goes wrong with the facts. Practitioners are too much in a hurry to issue a summons or to file a plea. Well, they're never in a hurry to file a plea. Usually there needs to be a notice of bar and everything. So what happens when you're in a hurry? The summons ends up coming out of your favorite precedent, the office precedent, or all out a copy of Ambler. This is wrong. The judge will not listen to you. Now, let me tell you something. If you draft rubbish papers, you are on the back foot already. Because let's say you went to trial. The judges, I can tell you all the judges, only read the pleadings bundle. They ignore the notices bundle. It's full of nonsense anyway. They read the pleadings bundle. Now, if you drafted particulars of claim from where it is not clear what the cause of action is, nor is it clear what your client's version is, and then you read a defense, a plea, which is a bare denial, what's the judge thinking? The judge is sitting in chambers reading this. Does the judge have a good impression of the plaintiff? Before the judge walks into court, the judge is also already thinking, but this plaintiff doesn't have a case. If he had a case, he would have pleaded it. Well, that's the problem, you see. The secret is to draft well, get it right the first time. This business of amendments, attorneys and advocates think, okay, if I get this wrong, we can still amend it. We can amend any time before judgment. It doesn't work because each time you amend, your old pleadings are still there. And they remain there to discredit you in the trial. So what makes the judges listen to you? Pleadings that make sense and disclose a cause of action or defense based on a peculiar set of facts. That the judge understands and will be willing to listen to you. A compelling version of what happens. So when is a version compelling? Is when a judge listens to it and thinks, that is likely to have happened. I like that version. Okay, I'm going to listen to it. The version must be consistent and support your client's cause of action. So, when a witness takes the stand and the judge is listening for half an hour and can't work out where that witness's evidence is relevant to an issue. So in other words, there's a disjoint between the pleadings and what the witness is saying. Now, you must have seen this in court, where a witness is testifying for half an hour, and the judge looks up and says, Mr. Jones, is there any point in this witness? Or what's the point? I don't see the point. When judges say, I don't see the point, in plain language, it means, what's the relevance? I've read the pleadings. I don't see the relevance of this witness. Okay. An adversarial judge is not looking for the truth. The judge was not on the scene and is confined to the version presented by the parties. And there's the golden rule of evidence. The evidence must be relevant to the issues. There's nothing that irritates judges more than to call a witness who is irrelevant to the issues. That's an abuse of court time. The facts that you present, the evidence must be admissible. And thirdly, the version must be probable in relation to the facts of the case. The same applies to the defense. Bare denials are just not helpful. A bare denial doesn't tell the judge anything, okay? And the judge is not going to speculate and find a defense for you. Okay, all right. I'm going to give you a short break before I move on to this new topic. Can we take 10 minutes, please? All right, come back at 10 to 1. 10 minutes to 1, okay? Right. All right, let's get started. We mentioned earlier on that the most important task for you is to obtain the facts of your client's case. Now let's look at where you would look. Statements from client. Now, statement from witnesses. Let me say something about that. You know, I litigated for years. I mean, I've spent the last 40 years of my life in courtrooms. We never saw witnesses until we were preparing for trial. And that was maybe 2 weeks before the trial, or a week, or the week after trial. You start talking to witnesses. But that is so wrong. You can't look for witnesses. Firstly, if you look for them close to the trial, you might not find them. And then you've got a problem. What happens if the witnesses disappear? You don't have a statement. But how do you work out your cause of action if you haven't spoken to the witnesses yet? How do you know that your client's version is going to be supported by witnesses if you haven't spoken to the witnesses? So get out of this habit where you obtain instructions from client, and then you proceed with the preparing particulars of claim or a plea or a founding affidavit. You need to get the witnesses immediately. Documentation. In any dispute resolution, documents are very important, especially documents that represent a contemporaneous proof of what happened. That is why in commerce, the parties sign an agreement. Then there's this thing called visual evidence. This is when you present the judge with photographs, diagrams, models, videos, and so on. Oral evidence that is supported by visual evidence is far more effective than oral evidence without visual evidence. That's a fact. And I'll say more about visual evidence later. You need to identify experts now at an early stage. Many of you are familiar with personal injury cases, you know, accident injuries, medical negligence, and so on. If there's been a serious injury, you need experts at an early stage. They will help you prepare the particulars of claim, the details of the injury or the negligence that was involved, and of course, the quantum. You have to plead in terms of the rules. You have to say how the amount is arrived at. An expert will tell you. But these days, we encourage parties, no matter what kind of matter it is. It could be a building dispute, an engineering dispute, an aviation matter. Those things need experts. Get them in as before you issue the summons. In fact, when you write your particulars of claim, you should get the expert to read it and tell you if they agree with it. Okay. How do you do this? When you listen to your client, I told you the first thing is to work out if your client's version is likely to have happened. And I told you a test is, do the undisputed facts support my client's version? If it does not, I promise you, you've got a problem. You've got a big problem. Establish that you have supporting evidence in the form of reliable witnesses on corroboration and credibility. Make an effort to already take steps to secure the presence of the witnesses on trial date. Now, you have no idea the number of trials that were frustrated because a witness who promised to be there never turned up. It's a common occurrence, but you can mitigate that by taking steps of your own as the lawyer to get those witnesses to court. You need telephone numbers, addresses, arrange transport. All of those things need to be done. Now we come to an aspect of fact-finding which took many years to find traction in our courts. And it happened because of a number of serious mistakes that happen in court. There are judgments around this. It's when parties present their facts to a judge without taking any trouble to present it in a chronological sequence. Now, as a lawyer, get into the habit of sequencing everything. Your client is sitting there and telling you a story. Listen to it, but then say to client, hold on, let's start again. But this time we go step by step from start to finish. In other words, you're saying, let's hear the story in a chronological sequence. Now, why is this so important? I told you, you have to constantly measure the probabilities of your client's version. How do you measure that? Well, I told you, one of the techniques is to see if the unopposed facts support your client version. There's another technique. Ask yourself if the chronology makes sense. If your client's version is sequenced and the sequence makes no sense, the version is improbable. That's it. Throw it out. Okay? Now, judges know this. What we've done in our courts recently, I'd say the last 5 years or less, we now require parties to file what are called chronology documents. So, for instance, if you bring an opposed motion, you have to file a chronology document with your heads. In the appeal courts, SCA, constitutional court, it's in the rules. You are compelled to file chronology documents of the main events in a sequence. Why is this important? It's because if you ignore the sequence, you might actually end up with a version, accepting a version that is inherently improbable. And then you'll discover the mistake later when it's too late. And in simple language, if the sequence does not make sense, the version is improbable and it will damage your case. Documents, very important. Never, and I mean never, review documents before you arrange them in a chronological sequence. Clients have the habit of bringing you documents informally, in a packet, in a box, in a file. They just dump it on your desk. You will be a fool if you read those documents without first sequencing them, then reading them through. If you make the mistake of randomly reading the documents without sequencing them, you will be misdirected. That's the danger, okay? And I've seen this happen so often only because the parties did not do sequencing. That is why our courts are now making it compulsory. Now, if you are working, if you are running a trial, if this matter is going to go to trial, you must start preparing your chronology document at an early stage. You should also have a separate chronology document for each witness. Your client and all the witnesses, you must prepare a chronology document. Now, chronology document is very simple to prepare. It has 3 columns. The first column, extreme left side, is a very narrow column. It's just for numbering, referencing, paragraph numbers. The middle column is the description of the event. Only the material events, not details, not the facta probantia, it's facta probanda, that goes in here. And the last column, extreme right-hand side, you put in the date. And the events are then noted on a single page in a chronological order, and that helps the judge. It helps you in the trial. It also helps you when you're leading your witnesses. When you start with a chronology document, you'll find that as you develop the facts, that document will have to be amended. It will evolve as you go along. The reason I say you must start a chronology document right at the beginning when you start taking instructions, firstly, it keeps you on track. You can see when this thing goes wrong. If the chronology stops making sense, you put on the brakes, you go in and see why. It is excellent for preparing because when you get to court in a trial, one of the documents you must prepare for the judge is a chronology document for the judge. When you stand up to argue, when you stand up to make your opening statement, that's when you say to the judge, my lord, I have, for your lordship's benefit, prepared a chronology document. Hand it up. It works brilliantly because what the judge does, keeps it on the desk. And as the events, as you call your first witness and the evidence starts flowing, the judge follows it in the chronology. And the judge knows exactly what's coming next. The judge will know what's the relevance of that witness. So it works brilliantly, okay? So start it at an early stage. Now, what you see here is we call the case concept. I spoke to you about earlier. I told you that you must know what happened according to your client's version of the facts. That we call the case concept. Now, you will also hear it being called the theory of the case. The Americans call it the theory of the case. We call it the case concept. Now, what is this thing? When you run a trial, you start off by issuing summons. You prepare particulars of claim. That sets out your cause of action. Now, all of that depends on your case concept. So your cause of action is based on what happened according to my client's version. That's what it is. Now, that concept, what happened, is what flows through the whole process. From summons to final argument, it's there as a constant. It's like a golden thread that runs through the whole process. You develop the case concept from the facts and the supporting evidence you gathered. From this, you have to formulate a cohesive and persuasive story to convince the judge that this is a true version of the events. That's the important bit, okay? That's the persuasion. Now, the first process, once you've got the facts, now you have to work out the cause of action. Now, I've underlined this point, and trust me, there's a problem here. It is easily the most difficult task for many practitioners because what you get from your client is a story, is a version. You as a lawyer must take that and turn it into particulars of claim. Now, the rules tell you that the particulars of claim must contain a cause of action. In other words, what you have to plead those facts which the law recognizes as giving you a claim. How do you take a set of facts and make a sustainable cause of action out of it? Well, let's deal with that. Now, I've given you a warning here. And I think I've warned you about this a dozen times. Wherever you encounter a set of facts or a version that seems implausible, in other words, you don't believe it, stop, clear it up. Do not proceed, nevertheless, on the basis that those are my instructions. You're heading towards a loss, I can tell you. The judge will find your version improbable. So what is the cause of action? There's the definition. Set of facts giving rise to a claim recognized by law. The facts the law recognizes as giving you a claim. So how do you formulate this? By now, you've got all the available facts. So you've got the witness statements, you've got the documents, you've got the visual evidence, you've got everything. Now using numbered paragraphs, write down what you see as the material facts of your case. The main facts as to what happened. You extract all the main facts that represent what happened according to your client's version. Now, using numbered paragraphs, write down what were the consequences for your client. What happened to your client? Did your client suffer a breach of the contract? What happened as a result of the breach? Did your client suffer damages? Does your client want to enforce the agreement? Okay. You have to itemize the loss or damage suffered by your client. So remember, you are writing all this down. You're not just reading your statement and thinking about it. One of the most important aspects of writing is that there's nothing like writing to concentrate your mind and force you to think about what you're doing. That is why when you use a precedent to draft pleadings, it's nonsense simply because one of the worst consequences of using precedents is that you stop thinking. And the minute you stop thinking, you're not being a lawyer. Lawyers think all the time. They're applying their minds all the time. There's application of logic, reasoning, rationality, probabilities. That's what a lawyer does. When you cut and paste from a precedent, well, any mampara can do that. You're not thinking anymore. So, right, at the end of this exercise, you will understand the context of the matter. You will know what happened, and you will know what area of the law is involved. So first you get the facts, then you contextualize the matter. Contextualizing the matter means you work out what area of the law. Is this contract? Is this delict? Now, I can tell you in your practices, 85 or even 90% of the summons you issue out will be either contract or delict. Then there are other causes of action that form the rest of the 10%, like divorces, family law matters, things like enrichment, defamation, those things. But mostly it's going to be contract or delict. Well, defamation is delict anyway. So now, if your knowledge of the facts is good, you'll have no difficulty in identifying the appropriate area of the law. So facts contextualize. The law is vast. You don't have the time in practice to behave like an academic where you have hours and hours and weeks to research something. You remember, you'll be expected to convey to the defendant what is being demanded and what is the reason for the demand. That's what particulars of claim should tell the defendant. Now that you've got the facts, you've contextualized the matter, research the law. Find out what the law says is the remedy. So if you have these facts, you know that it involves contract. Now, what does the law of contract say if you can prove these facts. Oh, the law says, if I can prove these facts, you can file a claim based on a breach of contract. Okay, now you know what to do. Now, remember, you have to write as you go along in numbered paragraphs. The reason for that? That's where your first draft is going to come from, okay? What are the essential elements or ingredients or material facts of your proposed cause of action? Write this down, okay? In numbered paragraphs. Where do you find this? Where do you find the law? Two places. If you are not familiar with the area of the law, then go and read the general principles in a good textbook. But what you're going to consider for purposes of drafting is the common law. In other words, you're going to read the cases, not the textbooks, case law. The most persuasive authority is the most recent decision of the highest court. Never forget that. That's all you need. The most recent decision of the highest court. That's the law, and that's the law you're going to use. So at this point, you made two lists, a list of your client's material facts, including the events, and a list of the essential elements of the cause of action. Now, do you see what we've done? You can put the two lists together. Here's my client's version. These are the requirements of the cause of action. Now you do a simple exercise. Can I satisfy these requirements with these facts? If the answer is yes, bingo, you've got the cause of action, okay? Now, those of you who haven't got this book yet, this one, Practical Drafting Skills, I wrote it. It tells you exactly how to draft without using precedents. All of this is you are taken through it step by step, and you'll actually write on your own. I know of many, many practitioners who call me all the time and say, look here, we are now drafting on our own. We got rid of our precedent file. And that's what your aim should be. Get rid of the precedents. Your precedent file must only have commercial documents. There you must use precedents. But for litigation, where every case is different, you will get yourself into trouble if you get stuck on precedents. Now read through what you have written and ask these questions. Can my client's facts be sufficient to satisfy the essential elements of the cause of action? In other words, will your material facts be enough to satisfy those legal requirements? If not, then there's a gap in the version. You need to take further instructions. If I can prove my facts in court, what does the law say is the remedy? What am I entitled to claim? The case law tells you that. Can I provide proof of the facts in the event of the defendant disputing them? Very good question. When you've got a set of your material facts, you're going to, at this stage, at an early stage, you have to apply your mind to proof of those facts. In other words, if in the pleadings your opponent disputes a material fact, it then means that you will have to provide proof of those facts on a balance of probabilities to the judge. That's being persuasive, okay? So, who will be the witnesses? Are they available? What documents do you need? Do they support your client's version, or do they contradict it? You see, part of discovery is to also discover documents that are against you, okay? Having answered these questions, you've established the cause of action. Now, just take my advice. This is not impossible to do. It's a simple technique. You will only learn it if you practice it do it yourself. Now, I know you're worried that you may not get it right. But you'll be wrong if you say, well, I don't think I can get this right. I'll use a precedent. Or worse, I'll send it to someone else to draft it. Well, by the way, if you keep sending your pleadings to someone else to draft, you know what that means. It means you lose 2/3 of the fees every time you do that. The idea is to keep the fees in your own practice. So do it yourself. The only way you do it is to write on your own. Back yourself, write. And you know what? We all make mistakes and we all pay for those mistakes. But if you don't make mistakes, you'll never learn, okay? So now you have two lists of facts. They represent the facts the law recognizes as giving your client a claim, okay? So now I've referred to Practical Drafting Skills. That's the book. Get it. The particulars. Most lawyers don't realize that if you draft bad pleadings, if you draft a poor set of particulars, you are on the back foot already. You are going to be in trouble from the start. And all you're going to do is you're going to try and recover yourself from a hole that you dug for yourself in the pleadings. Draft particulars of claim that firstly set out a cause of action and secondly sets out the material facts of your client's version. Now, why do I say do not use a precedent? Because you'll never find those two things in a precedent. What precedents do, for example, most of you are familiar with harams. Use harams. That does two things. Harams is useful for the following. It tells you what are the legal requirements for a particular cause of action. And it's very useful in that it gives you case law. What it cannot give you is a version. That it can't do. What it cannot give you is a version that is compatible with those legal requirements that you read in harams. So what do people do? They get harams, they copy and paste that out and use it as a precedent. It was never meant to be used as a precedent. It's a useful work, but you must know how to use it. If you use it slavishly and just copy and paste from there and file, you'll get into trouble. If you act for the defendant, you must answer the substance of the claim. So, in other words, if the plaintiff says, on such and such a date, defendant committed a breach of the contract, you cannot respond by saying the allegations are denied as if specifically traversed and plaintiff is put to the proof thereof. I mean, really? I mean, that's just precedent nonsense anyway. It doesn't tell the judge anything. It's not a defense. It's just a bare denial. Now, as a strategy, there's this question of duty to begin. When you draft particulars of claim or a plea, apply your mind to the question of onus and the duty to begin. Now, there are two separate things. Onus never shifts. If you attract the onus as plaintiff, it remains with you. He who alleges must prove. The duty to begin can shift. That's at the trial. Depending on how the matter is pleaded, usually, I would say in 9 out of 10 cases, or possibly more, the plaintiff has the duty to begin. But in a number of cases, the defendant might admit the plaintiff's claim and put up another defense. There, the defendant will have the duty to begin, okay? So bear that in mind. The idea is to avoid attracting the duty to begin. But sometimes it's not possible. For example, if the defendant is sued on a suretyship, and the defendant admits his signature on the suretyship, but then pleads that he's not liable to pay because he signed under duress. Well, at the trial, the plaintiff will just turn up and say, here's the original suretyship, may I hand it up? I rest my case. The duty to begin is on the defendant, who must now set about proving the duress, okay? As a plaintiff, the burden of proof will usually be on you, the plaintiff, but the duty to begin will shift. So do you apply your mind to that? It's very important. Now, when pleadings close, by the way, this is something you need to know. In many jurisdictions around the world, they have scrapped pleadings. For instance, in England, in Canada, United States, Australia, they don't have particulars of claim anymore. And the reason for that is because the lawyers have turned particulars of claim into highly technical documents which are not helpful. Usually because the lawyers want to say as little as possible, play their cards close to the chest. But this is not a flippant poker game, okay? You're dealing with dispute resolution in a court. So you're not there to play games. So the particulars became, it didn't serve the purpose it was there for. Same with the plea. I mean, go and read the way a plea is drafted. It's mostly denials. No knowledge or bare denial. Not helpful, okay? So when you draft these highly technical documents, judges read it and they find it's of no use. So what they did, they scrapped them. Now in the place of particulars of claim, you have a statement of claim coupled with a certificate of truth. So it's even better than an affidavit. The plaintiff tells his story and then certifies that what's in there is the truth. The defendant doesn't file a plea, the defendant files a statement of defense. Now, those of you who are familiar with arbitration, you will see that in arbitration, that's what they do. It's statement of claim, statement of defense. So currently, the particulars and the plea are still in place, and they will be for many years to come until our rules board wakes up. So now we go into the next phase, when pleadings close. When pleadings close, you have to call client in, and this is what you have to do. How do the pleadings impact your case concept now? Now remember, you started off with a case concept which says, this is what happened according to my client's version. But remember, it's not cast in stone, because now you are going to get a plea, you'll see the defense, then you're going to see the discovered documents. And also, by the way, swapping of witness statements, that's compulsory in most jurisdictions. We haven't done it here yet. It happens in arbitration, but in our court, not yet. We've lagged behind. Swapping witness statements is brilliant. It's absolutely brilliant. It makes more settlements than anything else. You know that, how many of you have been to pretrial conferences where the parties are making an assessment of how long the trial will run? Because you have to put it in the minutes. Whether it's 3 days or 4 days or 5 days, you'll have to make an estimate and state it. I mean, it's quite hilarious. Plaintiff will say, well, I've got 2 witnesses. The defendant will say, yes, well, we have 4. But in fact, that witness's lawyer hasn't got a bloody clue who his witnesses are. He's just saying 4, okay? because now it has to be more than the plaintiff. So, okay, so now we've got 6 witnesses. This case could run 4 to 5 days. Okay, what a lot of nonsense. Whereas if they had a statement of claim, statement of defense, witness statements, you can just see where this case is going to go. Okay, and it never runs for more than a day. So once pleadings close, you'll have to adjust your case concept. What facts have become undisputed? And do these undisputed facts support your version or your opponent? That is a vital exercise. Never forget to do it, okay? Pleadings are closed, admissions have been made. Now you've got an even bigger list of undisputed facts. Which version do these undisputed facts support? Which of your material facts have become disputed? You need to make a note of that, make a list of it, because now you have to apply your mind to providing proof of those facts. Now, if you did the work properly, you will already know who the witnesses are. You will know what documents you will need. It shouldn't be a problem. It should work quite seamlessly. You will need to carry out what is called a proof analysis. What is a proof analysis? You look at a material fact. If it's disputed, now you have to work out how you're going to provide proof of that fact. Now that's the analysis. You're going to make a note of the names of the witnesses you'll need, the description of the documentation you will use, description of the visual evidence you will use. Now look at the plea. Does it disclose a defense? If so, what is it? And if they do have a defense, does your client have an answer to it? Okay. Those of you who have got my book, there is a very effective way to plead your defense. My advice is, don't use this old method of starting with paragraph 1 of the particulars of claim and then going add 1, add 2, add 4, add 6 to 8, and so on. That's not very good. It's not persuasive, not good drafting. The way to do it is to say add paragraphs 1 and 2. Those are the description of the parties. You can say allegations are admitted. Then you have a separate heading that says defendant's response or defendant's defense. Underline that. And now, in one paragraph, using subparagraphs, state your defense in full. In other words, put up your version right there up front. Judge reads it and says, right, here's a defense. Works brilliantly. It also makes the rest of your drafting so much easier because now you go paragraph by paragraph and you simply say, you cross-reference. For reasons stated in 3.4 above, the allegations are denied. See, easy. But the most effective thing about it is that when a judge reads it, remember the judge read the particulars of claim, knows there's a case. The judge wants to see, is there a response to this case? And what is the response? What's the defense? Now, the old way, the judge has to read through maybe 20 pages of your pleadings to work out what the defense is. Whereas in this method, the judge reads it up front just like that and says, wow, here's the defense. I see it. Very persuasive. But let me give you the bad news. The bad news is you can only use that technique if you have a defense. If your client doesn't have a defense, you can't plead like that. Now, update your chronology document at the close of pleadings. You have to update the chronology document. When you see the discovered documents, update it as well. Finally, and most importantly, can you identify the issues between the parties? You write it down. And you don't have to write it in the words of the pleadings, write it in your own words. This is the issue. It's an essential step, I'll tell you why. In many of our divisions in the country, when you present the pre-trial minutes, you have to state in the minutes what the issue is. And you have to state it in your own words. You don't say, refer to the pleadings, because we know the pleadings are not helpful. You have to say what you and your opponent have agreed is the tribal issue. So make a note of it now already. When it comes to discovery, I told you you have to deal with discovery. And once you have identified the issues, so the first step is to get the issues, get the facts, identify the issues, now find documentation that is relevant to those issues. Now, if you did your work correctly, in other words, you got the documentation up front, you have a file with the documents in a chronological sequence, brilliant. It's done already. Your schedules are ready-made. Now, you know, those of you who have been in practice for a while will know this. When it comes to drafting the discovery affidavit and the schedules that are attached to it, who does it? Who does that affidavit in the law firm? The firm I was in, they had 2 paralegals. You took your file, you were told, this person does discovery affidavits. That's her job. So you take your whole office file and you plonk it on a desk and you tell her, Mrs. Jones, can you prepare the discovery affidavit here? And she takes it and puts it on the desk with the rest of the files and she proceeds to draft it. Do you see the ridiculousness of this? The one person in the firm who knows absolutely nothing about the case is drafting the discovery affidavit. Do you see how stupid that is? That is why you will see everything being discovered. I mean, Mrs. Smith is not a lawyer. She's not she doesn't know the case. She just takes everything out of your file and sticks it in one schedule or the other. So you end up with a bundle of 4 lever arch files to hand up to the judge. You'll be penalized. I promise you, don't do it, okay? So we want narrow discovery. Now we have electronic discovery, which is what, let me say something about e-discovery. It's very important. I can't imagine there are any documents left out there that are not produced on a computer. I mean, nobody writes invoices out anymore or lease agreements. It's all produced on a computer. Even small businesses use computers to produce their documentation. So I would think that 100% of your discovery will come from electronically produced documents. Now, managing electronic documents shouldn't scare you. It is treated the same way as any other discovered document. In other words, you produce a copy, send it to the other side, put it in the schedules, reach agreement. Is it being admitted? Is it opposed? Why is it opposed? Why does it need proof? And the usual agreements apply. The difference is when you have to prove an electronic document. So when you have a document which you believe may well be disputed, as a lawyer, you tell your client you want to see the metadata for that document. Go and obtain the metadata, preserve it, download it onto a hard drive, or you can store it in the cloud and restrict access to it. In fact, you can store it somewhere which has restricted access, or you can encrypt access and it will require a password. The reason for that is the only way you can prove the authenticity of an electronically generated document is to use the metadata. Now, using metadata to prove documents is time consuming. It could require a series of up to 3 to 4 witnesses to do that. And judges will be very upset with you if you put your opponent to the proof of a document and then you don't challenge the witnesses. Oh boy, you're going to get a serious clap from the judge. The trick is for you to go to a pretrial conference and say, I have proof that this document is authentic. I will give you access to the metadata. I want you to admit this document. And if they don't admit it, say, can we have your reasons for not admitting it? And they'll give you their reasons if there are. If there are no reasons, then you say, you have not given us a reason. We will then call the witnesses. If you are not going to challenge those witnesses, we will ask for a punitive cost order. Put it in the minutes, record it, okay? There's a step-by-step method of on how to handle electronic discovery. I co-wrote this book with Terry Harrison, who is an English lawyer who has extensive experience in electronic discovery, practiced in the United States and the UK. It's from LexisNexis. It's called A Guide to E-Discovery in South Africa. It's not a big book, but what's useful about this book, it contains a glossary of all the terms, the jargon that gets used with electronic documentation, and it gives you a step-by-step explanation of how to prove it in court. Okay. Now, e-discovery is the retrieval of materials originating from a computer, and it extends beyond computer files to encompass the analysis, gathering, processing, review, and production of discovery materials in electronic format from start to finish. The basic principle is that information that is stored, used, or transmitted in electronic form should be available through discovery with the same process as traditional forms. The only difference is the method of producing the document and also proving it. Proving a hard copy is easy. You get what is called an original signed copy and you hand it up in court. There's no such thing as an original signed copy of an electronic document. If you produced an invoice out of a computer, well, what's the original? It's the data that's in the hard drive. And you can produce that in court and present it with the metadata. Okay, learn how to use metadata. This book tells you, I've given you a reference to the book. Now, case conferences. I say they are underestimated. Case conferences can win you your case right there. And case conferences are brilliant at triggering settlements. You know that from Rule 37, you are expected to discuss settlement in a pretrial conference. It's an agenda item. But you know what we did? We went to these conferences and we got to the item on the agenda, settlement, and we just noted parties discuss settlement, unable to settle. That's it. Standard response. We never talked about it. Well, that's ended. You can't do that anymore. You have to actually discuss settlement. There must be minutes of the meeting. Now, many courts around the world have introduced this thing called a settlement conference, where the parties are compelled to sit down and discuss settlement. They must minute that meeting, and those minutes can be made available to the judge later, especially when a cost order is being argued. Rule 41A has come a long way towards that goal. In terms of 41A, you are expected to discuss and possibly settle the whole matter. Alternatively, some of the issues or certain elements of the case. You are encouraged to cooperate with your opponent and attend case conferences. Now, case conferences, you'll have two types. One is a case conference with a judicial case manager. In this country, it'll be a judge. Or you can hold case conferences with your opponent. Now, in the past, we only met our opponents in what we knew as the Rule 37 pre-trial conference. Well, now you are expected to meet more often. It's called case conferences. You write to your opponent and say, can we have a case conference? This is the agenda. And your opponent cannot say, no, we're not interested. If that's what they do, then there's Rule 37.9a. It's on the screen. You get opponents who are terribly adversarial. They'll tell you to go to hell, or they won't respond to your email. They don't answer their phone, and they're quite difficult to deal with. Don't be afraid. Make a note of all the attempts you made and all the details of being rebuffed by your opponent, and then use 37.9a to make them pay the costs. Judges these days will grant you an order. Okay. So, what do you expect with case conferences? Focus on what you believe to be the main tribal issue between the parties. Now, again, write it down. Don't take a highlighter and highlight the plea. Okay, write it down. The reason you also write it down is because it doesn't often emerge from the pleadings. Under case management, that's what is required. Now comes a crucial step. Be prepared to reduce the number of issues. You know, the pleadings might identify 4 separate issues, but the parties know that it's not necessary to deal with all 4 of them. One of those issues will be resolutive of the whole case. Good lawyer puts his finger on that and makes a note of it. Once you've defined the issues, now work out which issue will be resolutive of the whole case. That's the one you take to court. A judicial case manager will insist on you doing that. And judges love it. You go with the minutes, and in your opening statement, you say, my Lord, may I refer to the minutes, paragraph 8. Your Lordship will see that we have agreed that that is the issue for trial. You're off on a great start. The judge loves it. The judge smiling and says, right, call your first witness. Your opponent, if your opponent believes that there is a different issue, then your opponent must write it down. And you'll present both to the judge. Okay. Now, one of the most important objects of case conferencing is to reduce the court time, reduce the duration of the trial. One of the most important mechanisms for this is to demand admissions of fact that are not material to the main issues. And I say demand admissions, not merely ask for them, demand them. Now, here's a good strategy. Before you go to a pre-trial conference or a case conference, you must have an agenda, okay? Prepare an agenda, send it to your opponent and say, here's our draft agenda. They'll add their items and you'll have an agenda. But also important, prepare a list of admissions of fact that you require and send that list to your opponent at least 2 weeks before the case conference. Now, some of you may have attended case conferences where you've heard one party ask the other, will you admit the following fact? What's the answer? The attorney on the other side makes a great pretense of writing this down and says, I'll take instructions and revert. So it's a waste of time. Often you never hear from that attorney again. Now what we do, to avoid this taking instructions and reverting nonsense, we send the admission request 2 weeks beforehand. Now the attorney can't say, I'll take instructions and revert, but what were you doing for 2 weeks? And if the attorney ever tells you, I'll take instruction and revert, you say, listen, you've had this request for 2 weeks. Please tell us why you did not take instructions. I want to write it down. I'm going to minute it. Now you'll be taken seriously, okay? Now comes another very important tactical move. Very often your opponent will not make an admission simply because they want to make life difficult for you. They want to see if you can prove those facts. Maybe your witness disappeared and they will lose an advantage if they admit those facts. Well, that's not the test, okay? That's an abuse of process. Don't do it. And if your opponent is doing that to you, fix them. And I'm going to show you how you fix them. When your opponent says, I refuse to make that admission, you must say, please give us a reason in fact. In other words, a factual basis for refusing to make that admission. Okay. Now, the usual excuse is, no, we don't make that admission. Why? It's a matter for evidence. Okay. It's also nonsense. What evidence? Tell us, what evidence have you got that compels you not to make this admission? We'll record it. Now, if they don't give you a reason, if they can't tell you why we're not making the admission, simple, write it down. You put it in your minutes. Reasons for the refusal were requested. The defendant's attorneys or plaintiff's attorneys refused to give a reason. At the hearing of the case, should the defendant fail to challenge our witnesses, we will seek a punitive order as to costs. Now, I can tell you, most judges these days will not need an invitation from you to make a cost order against your opponent. When you call a witness in court, when a witness is called, let's say the plaintiff's witness is in the witness box testifying about a document, and the judge says to the opponent, cross-examination, and the opponent stands up and says, no questions, my lord, and sits down. The judges are trained now to immediately say to the opponent, hey, stand up, not so fast. Why was it necessary to call this witness? If you've got no cross-examination, why did you not admit these facts? If there's no explanation for that, and there can't be one, judge makes a cost order, okay? Now, if you've got a judge who's fast asleep, then you have to do it. You stand up and you must look surprised, eh? Your opponent says no cross-examination and sits down. You get up and you say to the judge, My Lord, that has come as a surprise. We asked for an admission of those facts. They refused to give it to us. And now we were waiting for some aggressive cross-examination to take place. This is an abuse. We want a cost order on the highest scale. You will get it, okay? Because we are not in court to play games with each other. If you have a basis in fact to deny a fact, that's good enough, because then you will present your version. But if you have no reason to deny a fact, or if the fact is not material to the facta probanda, the material facts of the case, well, admit it. It shouldn't be a problem. The idea is for you to get as much agreement as possible without having to compel. Okay. Now, we know that a regular agenda item for a pretrial conference is the presentation of documents and the composition of the trial bundles. I told you, discovery now, firstly, must be relevant to the issues, and secondly, must be proportionate. Proportionality is very important. I'll tell you what it is. Some of you may have heard of this phrase, document bombing, where you document bomb the other side, where you overwhelm the other side with so much documents that they can't cope with it and they settle. Document bombing doesn't really happen in this country. I mean, I haven't seen it. I haven't come across a case where that happened. But in the United States, oh my God, that happens all the time, where one company litigates against another company who happens to be a competitor. They now discover documents. They'll say, okay, we'll send you our discovered documents. Well, a truck arrives with men in overalls and trolleys, will now cart a room full of documents into your building. What are you going to do with that? If you're a small firm, you don't have the capacity nor the resources to go through thousands and thousands of pages of documents. The same with electronic documents. You send them files, megabytes of files. Who's got the capacity or the personnel or the expertise to go through all of that documentation? There's software, of course, that you can use that will go through documents and pop up what's relevant, but that's expensive. You may not have that software in your firm. Okay. So how did we manage that? We say no more document bombing. If you're going to practice document bombing, we're going to hit you with the costs. So only discover what is relevant to the issue for trial, and it has to be proportionate. You can't say, well, all these documents are relevant. We're sending you a truckload. Now, I'll give you a good example of a case like this in South Africa. I just thought of an example. Most of you may be familiar with the case of McCarthy versus Vodacom. There's about 3 reported decisions on this case. This became known as the Please Call Me case. McCarthy, who was an employee of Vodacom, claims to have invented this Please Call Me technology, which Vodacom used and made a fortune out of it. And then Vodacom reneged and said that no, actually it was their intellectual property, and they refused to pay him. Well, eventually he won. And where the problem comes from now is the quantum of the damages. Now, McCarthy is saying, wait a minute, you can't tell us you don't have all the documentation. You have to now go and tell us how many Please Call Me calls you handled and what was the revenue generated from each of those calls. Now, this is going back years. Can you imagine? That involves millions of data, millions. And it's all in electronic format. And that's where the case stalled, because now the parties went to court over how to access that data. Okay, it's quite an interesting case. There's a recent judgment of Collap and Jay on this issue of electronic documents. Go and read it. But the main principle in any of these conferences, whether it's with a judge or with your opponent, is cooperation. You need a sensible approach. Cooperate with your opponent. You know, it shouldn't be difficult to cooperate in Johannesburg because you don't really know the guy on the other side. We're too big. In the smaller towns, you know, if you're from a smaller town like Vereniging or Potchefstroom or Beaufort West, or a really small town like Durban, you know everyone. I mean, the Durban attorneys all know each other. Seriously, they do. And it's not difficult to break the and there they know, no, this guy's a difficult chap. He was difficult with me the last time. I'm going to show him this time. You know, that sort of nonsense can happen. It also happens here in Johannesburg. Many firms of attorneys have a reputation for being excessively adversarial. Just stop it. Just cooperate. Be polite. Be sensible. You'll get what you want in a case conference. So you agree on a trial bundle. It must be small. It will be small if it's relevant. And make sure it's then in the form in which the judges want it. Indexed, paginated, and referenced, okay? Now comes this question of experts, which is also in the agenda. Experts. Now, experts are quite heavily managed by judicial case management. Every division of this, in this country, High Court, has practice directives around experts. Now, why is that the case? It's because experts are expensive and they use up an enormous amount of court time. What judges have found out, or what we know, is that experts from the same discipline, let's say 2 orthopedic surgeons or 2 chemical engineers, they have the same training, they read the same books, they use the same techniques. They don't really disagree with each other. The disagreement comes from the facts that were presented to them by the attorneys. So now what we do, we say to the experts, meet with one another in the absence of the attorneys and file a joint minute. I tell you, 80% of the cases, the experts agree with each other. It's not necessary to call them. And all you do in court is that you have the summary and the report and the minutes of the joint meeting. That's it. You don't call the experts. The experts are excused. You save a lot of money and you save a lot of court time. So you must be ready to deal with experts in a case conference. Okay. Good lawyer would have had the expert on board from the start, would know exactly what the case is about, will have the reports, and will be ready to go to trial. It's only where there's genuinely a dispute between the opinions of the expert that you have to call them. And once again, if you have to call an expert, confine the evidence to that area of dispute only, because everything else is going to be admitted. Again, reduces court time. If there's a practical thing here, if you go to a pretrial conference or a case conference or a conference with a judge, always prepared an agenda beforehand. In this division of ours here in Gauteng, both provincial and local. You can't go to a conference with a judge if you did not provide the judge with an agenda. The judge needs to know what is it that you guys are looking for. And also agendas are helpful because then you go through the agenda, you don't waste time, you get what you want and you leave. Otherwise, you sit around and you talk nonsense and get irrelevant, and it wastes a lot of time, okay? Before you attended the conference, prepare the agenda. Now, what you do with the agenda, if you are the plaintiff, you prepare the agenda, or if you are the party calling the case conference, prepare the agenda, send it to the opponent, ask them to approve it, add to it, or remove an item, send it back to you. You then will prepare a final agenda that goes to the judge, okay? Now, here's another practical thing. You and your opponent have prepared an agenda. A very good idea is for you to meet with your opponent before you go to meet with the judge. In other words, you and your opponent must first get together, go through the agenda, see where you can reach agreement between yourselves. Eliminate those things from the agenda. Now, you might even not need the conference at all. You might sort the thing out. Then you write to the judge and say, sorry, we've reached agreement. We don't need to have a case conference. But you cannot do that if you do not adopt a reasonable cooperative approach with your opponent, okay? Listen, you might not like that attorney or that advocate, but put that aside. You are colleagues. You are professional people, so behave professionally, okay? Be cooperative. You can see, if you do all these things, I'm telling you, the chances are you won't go to trial. You'll settle the matter long before that. But if you don't, your trial will be a very short one. You will reduce the costs, okay? Now, here's a warning. Never, ever settle a matter at the doors of the court. It's what we call door settlements. If you can settle a matter before the trial date, you are expected as lawyers and officers of the court to do so. You are then supposed to send a practice note to the judge to say the matter has been settled, okay? If you come to court and you are allocated the judge, you walk into court and you say to the judge, oh, my lord, we've settled the matter. May we hand up a draft order? A judge will say, wait a minute. Why are you giving me this now? Why couldn't you have settled this thing at the pretrial conference? I've got the minutes, you couldn't settle. Why? Explain that to me. If this is a door settlement, I'm going to penalize all the parties with costs. Okay. Now, there's a reported decision on this. It was a judgment of Satchwell J. Malachi's case. Although it was set aside on appeal, it was set aside on a technical issue, but the principles that she enunciated in there are now being used, okay? So go and read that judgment. And then the final thing is, please, for heaven's sake, keep accurate minutes of the pretrial conference. My advice to you is record the pretrial conference, but don't record it secretly, you know, with a microphone in your buttonhole or something. No, tell your opponent, can we record the pretrial conference? Put the machine there on the table and switch it on. And because recording prevents you from being irrelevant, you'll stick to the agenda and you'll be done very quickly. And if there's a dispute over what was said and not said, you'll have it recorded. I have seen advocates at roll call arguing with each other in front of the judge president over what was said and not said in a pre-trial conference because they disagreed on what was in the minutes. It was a disgrace. I've seen it more than once. So keep a record. Okay, now I'm going to stop. I've been warned that my time is up here. We will continue with the post-certification process, and then I'm going to take you to the trial, okay? All right, so take a rest. I'll talk to you again at 11 o'clock tomorrow, okay? All right, Betty, I'm done for today.
Yes, there's no questions, Judge.
Okay. I'll make time for questions tomorrow. Before I finish, I will ask you to put up your questions. Betty will send them to me, and I'll try and answer them. Okay, thank you. See you tomorrow.